excuse me, a member of the, is a chairperson of the Medical Legal Association of South Africa. He's a former judge. He will be speaking on the issue of the seriousness of the crisis of medical negligence, on law reform, and on mediation. We further have Catherine, who is...
Okay, can you hear the director? No, she can't hear. She can't hear you.
We can hear sound, but not the director.
She can't.
We can hear.
I can hear you now.
Yeah, she can hear you properly now. Yes, she can
No,
hear
she
you.
can't hear Paul yet. She can hear the sound guy, not Paul. She needs to hear Paul. Yes.
I can hear you. Okay. 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 In that order. Okay. All right. Until. All right. Sure. Thanks.
And then one more thing, Amanda. I'm going to give you a countdown of 5 seconds or 10 seconds. But when I get 2, 3, I won't count you. I'll just do this. 3, 2, 1.
And
when
then I start.
It's a cue. It's a check for you. And then you start doing your thing.
Okay.
Whatever link that you have, and then Amanda. Okay, stand by.
How do you pronounce your company? Kamak. Okay.
Just relax now.
Yeah, I need to come on.
Just introduce yourself. My name is Amanda.
Was my introduction okay? Should I repeat it again? Okay.
My name is Amanda. You introduce yourself. And then because you know you introduce yourself. And then next one, that's it. And then it just flow. Let them flow.
Okay.
Okay. The camera that you are on now is that one.
Okay.
Next to that one.
That one.
Yeah.
Okay.
The one behind that one. After introducing yourself, you don't have to look at the camera all the way. You just do your thing and then talk to the panel.
Okay.
Thank you.
Just
Okay, 4 minutes to us.
Wait. Communication.
Just remember you're on camera 4 now.
I need to verify something before. Where's the minister? Is she coming after?
Not yet.
Not yet, so I shouldn't introduce her yet. So we're just going to start with her.
Just flow
Okay.
now and then we'll introduce that later.
Okay.
How about you meet? This is going to be your camera. Just for the intro and then do your thing on the way.
Okay. Yes. Thank you. Yeah, I will.
Okay.
Should I not sit there?
Okay, it's a minute, guys. Can I ask everyone to switch off your cell phones, or either I put them on silent because they're going to give us nasty feedback. Thank you. Amanda, this is going to be your camera, eh? Amanda? By everyone.
Good morning. Good morning to those who are tuned in. My name is Amanda Vilagazi. I'm an attorney and a member of the ANC Legal Research Group. Today we'll be having a discussion on medical negligence and the bleeding public purse. Medical negligence claims have become so prevalent. Our court rolls are cluttered with these sorts of claims that the ANC has taken upon itself to have this discussion in order on our panelists today. This debate will be covered widely. It could so that it could lead to possible law reform. Next to me is former Judge Klassen, who is a chairperson of the Medical Legal Association of South Africa. He will be covering this debate on the seriousness of this crisis, on law reform and mediation. Next to him is Catherine Berry. She is a director at Kamaku. It's an underwriter of indemnity insurance for medical professionals. She'll be covering this debate as far as how these claims affect the premiums, and as to the statistics and on other relevant issues there too. And next to her we have Acting Judge Enver Swart, who's also an attorney who does plaintiff work for claims, for acting on behalf of plaintiffs for claims of medical negligence. And then we have an attorney, Mr. Dion Francis, who also acts for defendant in the private sector. Basically, he represents these insurance companies who cover medical practitioners. And then we have Dr. Confidence Muluku, who is a qualified medical scientist. Dr. Muluki has a wealth of experience in public and private health sector. He's also a former special advisor of the Minister of Health. Next to him we have Mr. Likabe. Mr. Likabe is a state attorney in Johannesburg. He will be covering this debate in as far as how medical negligence claims affect the public sector, because as a state attorney they do defendant work on behalf of the Minister of Health. We have in our midst, here in her capacity as chairperson of the subcommittee of health and of health, and if I'm correct, yes, in the ANC. She's here representing national officials. I would like to call her Minister Naledi Pandor to come through to set the tone for this discussion and how it will benefit law reform. If you could come through, Minister.
Thank you. Thank you very much, Amanda. Yeah, you've introduced the panel very well, so I don't have to do the protocol stuff. I'm very pleased to have the opportunity to speak on behalf of our national officials and to welcome everyone to this ANC Legal Research Group workshop on medical negligence. The Legal Research Group has brought together a number of panelists who've been introduced to you. They will share their experience and knowledge of the current legal challenges facing public and private hospitals, the matters of the costs of medical aid, as well as the rising costs of medical insurance in South Africa. These, I think, are important issues for consideration by the African National Congress and the progressive health and legal formations within the mass democratic movement. Health, as you know, occupies an important place in the socio-economic protections created by the Bill of Rights in our Constitution. The provisions of Section 27 in the Constitution state that everyone has the right to access to healthcare services, including reproductive health care, sufficient food and water, and social security, including, if they are unable to support themselves and their dependents, appropriate social assistance. Now, given our Constitution and the rights that it affords our citizens, we've become an increasingly litigious society, and the matter of seeking legal recourse has really begun to occupy, I think, the wandering heights of the legal profession in South Africa. And just as in the United States, there's probably a great deal of abuse, but also there is exercise of rights, which is something that an individual does enjoy protection for in our Constitution. We as the African National Congress have as our goal the search to provide a better life for all our people, and that of course includes better healthcare provision. We spoke on matters of health in the Freedom Charter adopted in 1955, where we called for a preventive healthcare system which would be run by the state, that there would be free medical care and hospitalization provided to all who need it, with special care for mothers and young children. Our review of 20 years of democracy has indicated that there has been much progress. However, it does indicate that a great deal more needs to be done. We need to train the appropriate human resources in our country. We need to improve the quality of health care. We need to ensure that we have an approach to health provision that does give effect to the constitutional provisions and the aspirations of the Freedom Charter. We're very thrilled to learn that this workshop will provide the national officials and the ANC with an indication of approaches that might be adopted in policy or statute that would address the issues that will be deliberated upon today. Many of the recommendations and inputs of the workshop, as well as your comments, will be presented to the Law Reform Commission as it considers these matters. We would like to see improved quality of health services, as well as a decrease in the number of cases of negligence, particularly in our public healthcare system. I was looking with interest at some of the figures with respect to medical negligence cases, and I note that the costs to provincial health departments run into the millions in terms of malpractice claims. The Gauteng Health Department is facing negligence claims amounting to 1.28 billion rand for the 2012-13 financial year. The Eastern Cape faced claims of over 860 million in the last financial year, up from 4.5 million in 2006, and Northwest paid out 13.3 million in November alone last year for negligence at a state hospital. So these are very worrying figures. They speak to the matter of the quality of healthcare, because many of the claims are linked to matters of negligence, particularly with respect to children, thus indicating that in the provision of health support for babies, particularly and mothers, in our maternity sections, much more needs to be done. Improved training of nurses, ensuring appropriate equipment is available, and really reducing this cost to the public purse, which is totally unaffordable for our country. So we look forward to the deliberations of this morning and hope that we will add to a framework that does ensure South Africans that we will achieve the aspirations of the Freedom Charter and our Constitution of a quality healthcare system that provides caring, quality medical provision to all in our country. Thank you very much.
Thank you, Minister Pando. As the Minister has already set the tone for today's discussion, as I've already alluded, this debate will be covered widely or sufficiently by our panelists over here. As we are streaming live, you can send through questions through to our panelists on info.johannesburg@hoganlovels.com. info.johannesburg@hoganlovels.com. You can also catch us on Twitter on the SABC handle, also on Facebook on the SABC Facebook page. Our hashtag for today is ANC Legal Workshop. But Judge Klassen, you've already heard what the Minister has said in her address. You are going to you've prepared a short discussion on the seriousness of this crisis, the extent to which these claims have cluttered our court rolls. I am giving you the floor to maybe have the public hear what you have prepared.
Thank you. Thank you, Ms. Program Director. Yes, thank you, Honourable Minister. You've already covered much of what I wanted to say, but that's fine. Hearing it twice may be just the necessary impetus that we need. The medical negligence industry is in a serious crisis in South Africa. You've heard the Honourable Minister giving you some statistics. The statistics indicate that there is a tremendous backlog of medical negligence cases, not only against the private industry of private doctors and professional people, but also against the provincial health departments of the various provinces. One of the key problems with dealing with these backlog of cases is that when they ultimately reach court and a definitive judgment is handed down, the particular provincial government does not necessarily have a budget for paying those large amounts. And you may have read in the newspaper lately of large awards being given by courts against the provincial health departments, running into 10, 12, 13 million rand each. And if there's no budget to pay those amounts, then the money must be obtained from somewhere else. And the problem is that money is then usually obtained from budgets for the provision of new equipment, because there is no budget for medical negligence damages awards. If that happens, then it means there's less money to buy new equipment, which means that the older equipment also leads to further negligent claims. So it's actually a vicious circle which results in these claims increasing by the day. The Minister of Health, Dr. Motsoaledi, is fully aware of this crisis, and in March of last year, 2015, held a 2-day summit meeting with representatives from all stakeholders. There were about 450 people from all the various provincial medical health departments, private individuals, etc., And these issues were widely discussed there in separate fora. After that, the minister then appointed a task team to draft all of these suggestions that have been made at this summit into a declaration of intent. He has recently signed that declaration of intent, which will now hopefully become policy, and the policy document will then be further adumbrated by a committee that he is appointed to deal with these matters on a wide range, national-wide, and to advise the minister in that regard. So that is a very positive development because of the seriousness of the crisis in the medical negligence industry. Let me just briefly touch on matters of law reform that we at the South African Medical Legal Association are particularly and keenly interested in having referred to the South African Law Reform Commission. The first one is the whole question of lawyers' contingency fees. Now, for those that do not know what it is, it simply means that people who have no money to appoint attorneys or advocates can agree with the attorneys and advocates to act freely initially on the basis that if the case is lost, then that particular individual will have to pay nothing to the lawyers. But if the case is successful, then the lawyers can take a certain percentage of the award that is made as part of their fees. That is what is called a contingency fee basis for taking a case. Now, the original motivation for that system is well-founded because many poor people don't have the resources to obtain the assistance of proper legal representation to deal with their cases in court. But it has now escalated in some very negative side effects to the whole contingency fee basis. The one is that it enhances touting, and touting is illegal, and it causes touts to go to hospitals and walk from bed to bed and get people in bed to sign proxies to authorize attorneys to sue on their behalf the hospital, the doctor, the nurses, whoever, for possible damages. And the result is that many unjustified claims are therefore instituted against doctors and the medical hospital provincial departments. The negative effect of the contingency fees is well known and documented also in America, to which the Honourable Minister has also referred, and has caused many doctors to go out of practice because they could not afford any longer the large insurance premiums that have to be made to protect them against lawsuits. So the whole question of contingency fees would, in our view, be an aspect that needs law reform and to be reconsidered. Second aspect is the whole question of prescription laws. Now, if a claim is instituted by a minor or a baby who has suffered asphyxia or brain damage at birth, that individual's claim only prescribes or falls away after 18 years, which means that the mother and the father or the guardian of the baby who has been seriously injured at birth can wait for 18 years before instituting a claim for damages against the particular medical professions. That means by the time that a case comes to court, many of the people who were involved in the birth of that particular child have either died or have moved on to other departments or are no longer there. The medical records are not available easily, have either been lost, etc., which makes it very difficult for the state hospitals to defend themselves against these claims. We feel that there is much benefit to be obtained from law reform in reducing the amount of time that should be allowed for especially claims on behalf of minors to be instituted and not wait for 18 years. Then the third aspect where we feel law reform should be considered seriously is the common law rule of what we call in legal terms the once and for all rule. It simply just means that if you have a claim for damages, you have only one chance to go to court to claim those damages. Many of the damages that a person suffers in medical negligence claims are only suffered in future, like future loss of earnings or future medical expenses or future hospital expenses. But the law requires that all those future losses have to be claimed once and for all at the start when the case goes to court. But that obviously has its drawbacks, because you can imagine people instituting claims for loss of future earnings 10, 15 years down the line, but then in 2 years they die. Now they've claimed a large amount for future loss of earnings, and he has died or she has died. Who then uses that money? Obviously it then amounts to a payout to people who have not really suffered those damages. So that once and for all common law rule requires serious reconsideration by the South African law reform. Lastly, the backlog of cases are such that if they all were to come to court immediately, the entire judiciary and system of law will break down. There are just too many of them. We therefore need a very serious reconsideration of quicker and speedier and less costly method of resolving these cases. We in the South African Medical Legal Association of the view that mediation is a perfect alternative to litigation. Litigation has become too costly and is not speedy enough, whereas mediation is often very inexpensive and far quicker. Mediation is simply a method whereby skilled mediators who have been trained, and many of them are advocates and attorneys and doctors, assist the opposing parties to come to a joint decision where both are satisfied with the resolution of the dispute, which means that there are two winners, whereas in litigation and arbitration there's always a loser and a winner. The likelihood of a doctor-patient relationship being restored at the end of litigation is far less than at the end of mediation, where often just an apology or an explanation is sufficient to allow the patient to understand exactly what went wrong and how it can be remedied in a proper way. Now, the one aspect that concerns many lawyers is the question whether compulsory mediation is unconstitutional in violation of the right to go to court or any other form to have your dispute resolved by a court of law in terms of Section 34 of the Constitution. Well, my personal view is that it is not unconstitutional. Compulsory mediation has already been documented in about 44 different statutes. The Children's Act is a particular interesting example of where parents and guardians who fight about children are forced to submit their dispute to mediation before going to the children's court and embark on expensive litigation. And it works well. Therefore, we would like to ask the Law Reform Commission also to consider the amendment of law to include compulsory mediation as a first step before litigation. Of course, one can never take away the right to litigation, and therefore if mediation fails, one can therefore resort to litigation afterwards. But the parties involved in the dispute must be genuine in their attempt to mediate and resolve their dispute. And if they don't participate genuinely, then normally what one will include as a sanction is a cost order by the court, who subsequently hears the matter when the mediation fails. And the court can then decide whether one of the parties did not genuinely and bona fide participate in mediation and make an appropriate cost order as a sanction against such a person. We have found that the resolution of disputes by mediation is very, very cost effective. In all the mediation that I've been involved, there has never been a mediation longer than a day. And the cost involved far, far less than in litigation or in arbitration. So, Mr. Program Director, those are the three issues that I really want to address.
Miss
Thank you.
Program Director. Thank you, Judge Claassen. You've covered quite a mouthful there when it comes to law reform. There is questions that are sent already to you, but I think I will come back to pose those questions to you so that you can respond to the public. Catherine, Judge Claassen also mentioned to the fact that a lot of doctors will close their practices due to these high fees, insurance premiums they are paying. Now, you are better placed to tell us about what is the statistics and how these medical negligence claims affect these premiums. You can proceed.
Thank you. Well, Camargue Underwriting Managers has been underwriting medical malpractice since 2006. We've certainly seen a stark and dramatic increase in the quantum, frequency and severity of claims. There are a couple of things that we do attribute it to. Definitely the the cap on the road accident fund claims. Obviously that closed down certain revenue streams, which made attorneys look elsewhere to make up for it. The fact that the Law Reform Commission actually allowed contingency fees. And of course, even legislation such as the Consumer Protection Act, which just in general raised awareness of consumers' rights and what they're permitted to do. Nowadays it's quite commonplace to hear about your opportunity to have your medical negligence claim presented through TV, radio adverts, all that sort of thing. So it's become very commonplace and consumers are very aware of their rights. During 2011, Camargue started underwriting a facility for obstetricians and gynecologists. During that year, the claims paid out on that facility was 7.6 times the amount of the premium actually received in lieu of that. The following year, we saw 2 South African insurers withdraw from underwriting these specialists. And in fact, in 2014, Camargue followed suit. Now, the reason for that was the increase in severity and frequency of claims, and the bulk of these claims were baby-related claims. So the impact of that was twofold. First of all, there weren't very many insurers in the South African market that were actually willing to underwrite these specialists. And if they were going to charge an exorbitant premium. At that stage, gynecologists and obstetricians were looking at premiums of about 500,000 Rand a year. In contrast, a practitioner which an insurer considers to be low exposure, such as a general practitioner or something like that, their premiums are as low as 2,500 Rand per annum as opposed to the 500,000 Rand. So Camargue, even though we have pulled out of insuring obstetricians and gynecologists directly, we are still exposed to baby-related claims by lieu of the fact that we underwrite medical establishments which offer birthing facilities. So as you would probably know, in medical negligence cases, particularly of those involving babies, when there is a claim, it involves the gynecologist or obstetrician as well as the medical establishment which was involved with it, and they would be defendants in the case. So in our experience, the quantum of baby-related claims are usually about the mid-20 million Rand mark, and often they actually are settled outside of court in our experience. But you can imagine that if it had to go to court, the quantum of the claim would actually increase rather significantly. And you actually touched on some of the points that I was talking about earlier as well, is that's before you even start thinking about the issue of prescription. You know, once the minor does reach age of 18, they've got 3 years to institute a claim, which has already been addressed. And obviously it would be to try and address issues where they felt that they haven't been compensated sufficiently for their future medical expenses, loss of earnings and the like. The other problem which we have found in terms of practitioners purchasing their insurance is that they're not buying suitably high levels of insurance. So what we have found in general when it comes to these baby claims, which are rather large, the practitioner actually hasn't bought high enough insurance. So after the insurance coverage has responded to the claim, there's a balance which the practitioner has to fund out of his own pocket. And in some instances, we've seen the self-funded portion being as high as 10 million rand. When we were preparing for this, we started looking at some of our claims experience as far as the baby-related claims go. And it was quite interesting to see that, in general, 35% of the claim is actually attributed to loss of future earnings, and 45% of the claim is due to future medical and hospital bills. So there you have 80% of your claim just due to future loss of earnings and your future bills. Judge Claassen, you managed to touch on some of the things that I was going to talk about, so I won't belabor them too much. But I think something that we just have to consider is, first of all, the viability and sustainability of South African insurers actually offering medical malpractice. And in the instance where the insurance is available, what levels of premium are going to be charged to practitioners and whether they're actually able to afford it. When we were still writing obstetricians and gynaes, we actually had several insureds who cancelled their insurance because they just couldn't afford it anymore and they were literally closing shop. Obviously, it's a really grave concern to have these people who aren't able to procure insurance and who are potentially not offering their services anymore or perhaps functioning without the insurance. So it's certainly quite an important issue which needs to be addressed.
Well, Catherine, maybe a question could be asked as to what is the attitude toward defending these kind of matters from the indemnity cover point of view?
So Camargue doesn't only write medical malpractice. We write a range of insurances from public liability, slip and trip. And I'll tell you what, trying to resolve a slip and trip claim is a lot easier than a baby claim. The emotional aspect of it, and something which you touched on earlier as well, is often in medical negligence claims, people aren't always out just to get money. They just want to understand what happened. And for the practitioner to say, yes, I did wrong, we were negligent in this, and we are dreadfully sorry for it. And I think if people had to approach it more from that perspective as well, you'd certainly see a reduction in potentially the quantum and the severity of the claims, and also being resolved more amicably and not having to go to court. Particularly baby claims, it really is heart-wrenching to deal with a claim where, you know, this family have been wanting a baby for so long, and finally they have this little bundle of joy, and this little one ends up being born with cerebral palsy. And, you know, they have to adjust their house to be able to cater for the child's being able to move around. There's constant physiotherapy, constant medical treatment, medicines. So it really is a tough thing to try and defend. And we are fortunate in South Africa, and particularly here in Sandton, that there's a wealth of experience of lawyers such as Mr. Francis here, who are able to guide us through these very emotional claims.
Okay. Judge Claassen, when you spoke of compulsory, suggestion of compulsory mediation, would it suggest that there should be a compromise from both sides, from both the plaintiff and the defendant, to come to common, to a settlement of some sort of common ground?
Absolutely. That is the beauty about mediation, that mediators are trained how to guide opposing disputants to a point where both agree on a resolution that satisfies both. And if both are satisfied, then they don't have to go to court. They sign an agreement, and that agreement is then binding, and that is then the end of the dispute.
And the plaintiff should not come back later and say, I've got future medical expenses.
Once a mediation agreement has been signed, that's final.
Yeah. Now we go to Mr. Swartz, probably the most frowned upon in this discussion.
Yes.
An attorney who actually practices and specializes in personal injury, medical negligence.
Yes.
You assist these plaintiffs to pursue these claims.
Yes, Amanda. From my point of view, it's obviously in everyone's interest in regard to the topic of discussion here that the public purse should not be bled, and that the money that is budgeted for by the health department could be put to better use for the purposes for which it was intended to for in the first place. On the other hand, that does not mean that a claimant who has a legitimate claim should not be compensated fairly and justly. You must remember that this claimant goes to his doctor, whether in public or private healthcare, for the particular purpose of being assisted when going to see his doctor. And if he or she then suffers harm at the hands of the very medical practitioner whom he or she had gone to for assistance, then of course she has every right to be compensated for the harm and the damage that was suffered. Now, it is so. I'll give you a practical example. I was contacted very recently by a man who says to me, he sends me a message via social media saying to me that my grandfather went into for an operation to a provincial hospital on the east end of Johannesburg for an operation to his left eye. When he was discharged from hospital, they had operated on his right eye. He's now left completely blind. Secondly, a mother says to me that when I realized I was pregnant, I had gone to the local clinic in rural areas in the Northern Cape. She was treated and went for regular monthly checkups. The day before she gave birth, she went back to this clinic where the medical staff there said to her, your baby is exceptionally large. We do not have the facilities to treat your baby here, or you here. And an ambulance was summoned to transport her to a provincial hospital for the necessary treatment because she was to undergo a cesarean section. She says that on arrival at the provincial hospital, she was sort of abandoned, left on a stretcher and left in the corridors of the hospital, where she laid in excruciating pain until eventually she was attended to towards 2 o'clock, 3 o'clock the next morning. Eventually a doctor was called, and when the doctor arrived, there was a commotion between the doctor and the nursing staff, the doctor being asked why he was not summoned earlier. She was then informed that it was too late for a cesarean section to be performed, and she had to give birth via normal vaginal delivery. She says that became impossible, and forceps were used to assist in the delivery of the child. When the baby was eventually born, the child did not cry, and she was discharged home about a day or so thereafter. She says on arrival back at home, and after a while, she noticed that this child did not breastfeed, and the child did not reach any of the normal developmental milestones. She went back to hospital, the provincial hospital, where she was treated, and eventually she was told that something had gone wrong at birth. Now the question that I'm asking is, she then eventually, she was told that the child suffers from cerebral palsy, and that the child is now completely brain damaged as a result of injuries that could have occurred at birth. Now, the problem is that most of these victims of medical malpractice tend to be the poor and vulnerable, and they suffer life-changing and critical changes at these institutions where they go to for help in the first place. It is so that the medical professional has a duty of care towards that patient, and that is then where the lawyers come in, and where the lawyer has a duty to as a role to play. I think that as much as the medical practitioner has a duty towards the patient, so too does the lawyer there to assist the public at large. Now, Judge Claassen has touched on the issue of attorneys charging a contingency fee, which is governed by the Act. Now, many of these people, and all the attorneys here that's present here, doctors will know that in order to investigate the claim for and on behalf of a victim is an incredibly expensive exercise. It involves the assessment of a claim and it involves a whole battery of medical legal experts that has to assess the claim and to assist to eventually properly quantify this claim. Mention has been made of the once and for all issue. In other words, if you do not investigate as an attorney this claim on behalf of a victim properly at this stage, and a claim is undersettled, and you prejudice the plaintiff as a result thereof, then the attorney was negligent. Now, these victims do not have the money to pursue these claims. A simple medical legal report could charge, you could pay between 10 and 15,000 rand per report, and in the proper quantification of a claim, you will read up to maybe 20 of such reports. Now, that's where the attorney plays a vital role, because the attorney has the knowledge, the attorney has the skill, the attorney has the financial backing to be able to assist a poor and vulnerable client in properly quantifying this claim and making sure that eventually, when this matter comes to court, that there is just and adequate and fair compensation for this victim. Now, with regards to the how this claim is quantified, again, these are not figures that are just sucked from the air. Life expectancy experts become involved to determine the longevity, and that then is actuarially calculated, and that's how figures are arrived at. So without the assistance of an attorney who is able to take the risk in submitting these claims for and on behalf of victims, many of these people would not have access to courts. And the Constitution guarantees the right of access of everyone to our courts. I agree with Judge Claassen that mediation is probably a better way to go than going to court and eventually clogging up the court, the court rules. And it is true, I agree, that mediation will settle these matters much quicker, at much less expense, and it is certainly a win-win situation. But the problem is, I think for now, for the purpose of this discussion, is that the problem is not the attorney. The problem is not the attorney assisting the innocent victim here. The problem comes because you must understand that the attorney only comes in after the harm had already been suffered. In other words, it's not the attorney that created the medical malpractice. It is not the attorney that operated on the wrong eye. So the attorney only comes into the picture when he is consulted because of the obvious harm and damage that had been caused, not by any fault of the attorney.
Thank you so much. Now, what is your view on the issue Judge Claassen touched on about a contingency fees agreement?
Yes.
But probably the public and the perception about lawyers and these contingency fee agreements.
Yes, Amanda, I agree with you that if there's abuse of the system, if there is attorneys that overreach, that overcharge their client, the necessary authorities must deal harshly with that particular individual. Now, it is so, and we all are very aware of developments in the recent past of high-profile attorneys who had overcharged their clients. I see nothing wrong if the attorney operates within the parameters of the act that allows him to charge a fee at a certain rate. As I just said, you must remember that the attorney lays out the cash upfront to assist the claimant in being able to quantify this claim. If the attorney was not there to help this claimant, that victim would probably never be properly compensated for the damage that is suffered. And it's a careful analysis in knowing how to quantify this claim, because you cannot come back at a later stage. You must now, at this stage, sue for the past hospital and medical expenses that had been incurred. You must now, and this is with the means and assistance of medical experts that helps the attorney in knowing how to quantify a claim for your future hospital and medical expenses. And as I just touched on earlier, if someone has brain damage, a life expectancy expert will give you guidelines as to how long it is expected that this particular victim may still live, and that is then actuarially quantified in order for you to get to your figures on the correct figure for your future hospital and medical expenses, because this, when compensated, needs to be put away in a trust to ensure that there's no abuse of this money and that it is there for the future assistance of this particular person. You've got to sue for the loss of earnings or earning capacity. And then, of course, the general damages, which will being your pain, your suffering, your inconvenience, and the like.
Thank you so much, Mr. Swartz. We can now go to the gallery and see if there's anyone wants to ask a question. Can stand and tell us your name and surname and speak a bit high so that we can hear your question to the three of the panelists that have already spoken. The gentleman there. There's a mic coming for you.
Thank you, Judge Klassen and Mr. Swartz. This is a question specifically for you, but even Mr. Lekabe from the State Attorney could perhaps also tell us his views. A large part of the claims against state hospitals relate to what's called future medical expenses. In fact, that probably forms the major part of the claim. Now, what's happening is the claimants will get compensated at private hospital rates, but then still come and claim treatment from the public hospital, and then yet use that money for something else. Now, also what's of concern as far as contingency fees goes is that 25% of those, up to 25% of those future medical costs, which are claimed from the state, ends up going to the attorneys. So in any event, even if the claimant went to private hospital for their treatment, they would only be covered for 75% of their treatment. So could you perhaps address that issue? Thank you.
Look, Mr. Kaji, in my view, the Contingency Fee Act makes provision for the attorney to charge his contingency fee on the capital that is on the capital sum that is eventually awarded. Now, when the fee is eventually charged by the attorney, there's an agreement that is entered into between the attorney and his client. The client does not have to accept that the attorney does not have to accept the instruction, or the client does not have to see or instruct a particular attorney. Now, with regards to whether the fees would still be available, that's why I touched on it earlier, saying that, and you know, Mr. Kaji, that in these instances, trusts are created in order to protect those funds for the future hospital and medical expenses. If a claim settles today, it doesn't mean that a client is probably tomorrow going to need all of that in order for them to undergo this medical treatment. That's why these funds must be protected and to ensure that these funds are available in the future for whichever medical treatment may be required.
Thank you. Is there any other question? Oh, there's a question from lady there. Yes.
Thank you.
There's a mic for you.
Thank you. My name is Crystal Cambonis. This is a question relating, I think, to the insurance person, relating to nipping the problem in the bud. Many of us have tried to report doctors for improper or incompetence at the reporting thing. It is not possible. So, do you find repeat doctors, repeat offenders, the same names coming up again and again in certain places, and what can we do about cutting out that? And the second thing is about the insurance premium. I'm sure you're aware amongst the attorneys there's a fidelity fund in which attorneys pool interest, but whatever the means is, has that ever been looked at, that there's some pool amongst the legal profession, I beg your pardon, the medical profession, so that their top-up insurance is at a lower premium? Thank you.
Well, perhaps to address the last part of your question first, in terms of there being some sort of a pool of insurance premiums, I'm sure most of you are aware that the Medical Protection Society does offer insurance locally. That being said, it must be borne in mind that MPS is not an insurance company as such. And there are pros and cons as to getting your coverage from the likes of an MPS as opposed to an insurance company. So with MPS, you are not assured as to the level of insurance coverage which you will enjoy, and also they essentially have a council which would decide on whether your claim is handled or addressed. So we believe particularly that it would be more appropriate for medical practitioners in South Africa to rather be purchasing their insurance from local companies who are more experienced in the insurance sphere as such, and that are actual insurance companies. But I guess that's a whole nother debate for another day. We have certainly looked at all manners of ways in which we could try and address this problem. It really is a problem for the country as a whole, in terms of actually being able to provide medical coverage. As I alluded to earlier, but there have been a number of South African insurers that have actually withdrawn from the market. And it's not something that is specific to South Africa, it's all over the world. We're involved with Lloyd's of London, and if you speak to them, they talk about the Italian crisis. And they've all had this problem, particularly with baby-related claims as well. And I think one of the things that in general has to be done is that we need to start looking at appropriate risk management measures. So you were asking earlier, do we get to see repeat offenders, and how do we handle that? So when we consider taking on any type of risk, whether it's a practitioner or an establishment, they obviously have to provide us with certain basic underwriting information in terms of what are their activities, what are their procedures, what are their numbers of staff, have they had any claims or circumstances, have they had any requests for records from the HPCSA, the likes of that. And as an insurance agency, an underwriting agency, although we obviously exist for a reason as well, and that's profitability. So yes, we are selling insurance, but it's in our vested interest to do so profitably. So we take issues such as claims and circumstances quite seriously. And if we had to see someone who, even if they haven't necessarily been found guilty in terms of any HPCSA ruling or anything like that, you do find that it's, as the age goes, where there's smoke, there's fire. So if there's repeat complaints and all those sort of things, that's not a risk that we would really want to take onto our books as an insurer. Unfortunately, our underwriting methodologies and appetites aren't going to do anything for the public or rectifying the problem as such. But potentially, as you suggested, maybe there should be some sort of a mechanism outside of the normal HPCSA where, responsible reporting or reckless practices are actually reported to a central authority from others than perhaps just patients. But yeah, certainly a risk appetite thing for an insurer.
A great one. I think there is, I'll take a last question from the lady just in front.
Hi, good morning. My name is Terry Lee Dixon. The question is largely addressed to Judge Claassen. We're very aware that contingency fees are a problem in certain circumstances and that they have been abused. However, we also know, and you touched on this, Judge, that without contingency fees, the poorest of the poor in this country would not have access to litigation. And my concern is, if law reform is looking at taking away the contingency fee, what then would be the alternative to allow the people who cannot litigate without the contingency fee? What then would allow them to litigate?
Yes, that's a good question. My concern is more that the whole question of contingency fees should be re-evaluated to consider whether, for instance, the 25% payment of what is recovered is fair in all the circumstances involved. Secondly, to cut down very harshly on the whole question of touting. And this is where the health department can be of assistance as well. Very often when I address medical practitioners and hospital staff, I say to them that if a nurse or a doctor sees a person with a briefcase walking from bed to bed to bed, they are entitled to ask him, what is he doing there? If he's not a family member or a medical practitioner, then what right does he have to be there? And in every hospital, there is a right of admission notice at the entrance. And they should enforce that right of admission by removing these people who tout by going from bed to bed forcibly, if need be, because that's where the abuse of unjustified claims against doctors and provincial hospitals commence. That's where I think the law reform can be amended to ensure the whole question of touting being cut down and limited. There is now criminal sanctions against touting, although legal advertising by attorneys, of course, is quite permitted. But I think there is room for a reconsideration of that aspect. I agree with you that the motivation of contingency fees for access to justice is a noble motivation and should not be removed entirely. But the practical implications thereof need to be reassessed and re-looked at in its entirety.
Interesting. There's a comment from Dr. Mpho Rabada, which question I think is quite relevant towards Dr. Confidence. It's regarding the issue of staffing, medical staffing, which is possibly one of the elements that really result in this medical negligence. However, you can touch on it when you address us, Dr. Confidence. Our second panelist is, Attorney Dion Francis, who defends these insurance companies, as you earlier alluded, Catherine. You act on behalf of them as a defendant attorney. You are better placed to tell us as to what has been your experience or your observation of the extent of this crisis.
Thank you, Amanda. Catherine made two important points relating to the cost of medical malpractice cover. Over the past couple of years, we've seen a dramatic increase in the cost of professional indemnity cover for medical practitioners, particularly in the high-risk areas, your gynecology and obstetrics, your pediatrics, and your neurosurgery. She's also made another point that many insurers have stopped offering professional indemnity cover to medical practitioners. So this leaves the situation where medical practitioners have very little choice from a pricing perspective. And those who are offering the cover do so at high cost, and with the medical practitioners accepting a large chunk of the claim themselves as an excess. Now, because the insurance premiums or the cost of insurance is so high, naturally that affects the profitability of running a medical practice in South Africa. And the effect is twofold. One, those costs are going to be absorbed by that medical practitioner. So again, to reiterate what Catherine said, you're going to find a reluctance amongst your medical practitioners to specialize in those high-risk areas because it's just not profitable. I mean, at the end of the day, they are there to run a business as well. I read a scary statistic in a report published by the Medical Protection Society beginning of this year, which indicated that there are only 3 pediatric neurologists in the country at the moment, and all 3 practice in the public sector. So this increase that we are seeing in medical malpractice claims is going to, or could result in the country seeing a significant shortage of necessary medical specialists. The other aspect of this is the fact that the costs are passed on to the consumer. We already have exceptionally high private medical costs. These are not only going to increase as the prolificity of medical malpractice claims increases, but we are also going to see medical aid subscriptions increase accordingly. So that's going to push the private healthcare out of the reach of a large majority of our population who are already cash-strapped. Apart from the monetary implications of this increase in medical malpractice claims that we are seeing, it's going to also start affecting the way doctors practice. Doctors are well aware of the fact that they are operating in a very consumer-friendly and fast-becoming litigious society. So when treating patients, they know that if they are not 100% correct, the chances of being sued are substantial. The medical profession is stressful enough. Knowing that if you do not perform at peak performance, you're going to get sued, adds to that stress, which results in doctors being error-prone, which has this vicious circle which Dr. Claassen alluded to, where the stress brought about by medical malpractice claims results in more errors, which results in more medical malpractice claims. And a lot has been said on the Contingency Fee Act. Now, the final point which I need to make is that litigation is expensive. And with the increase in medical malpractice claims, naturally, insurers are becoming very alive to how expensive it is to defend these claims. Now, most attorneys who act on behalf of claimants do so in terms of the Contingency Fee Act. And I think that there is indeed merit in the Contingency Fee Act because it gives the large majority of our population access to our courts. In fact, most attorneys can't afford themselves. However, insurers do not have the benefit of the Contingency Fee Act. So when they receive claims, they have to make a business call. At the end of the day, insurers are running a business as well. Do we settle these claims or do we defend the claims? Now, there's definitely merit in settling the claims if there are merit in those claims themselves. However, we are finding that in order to save costs, the costs associated with litigation, insurers are settling claims to avoid incurring those costs because it is often cheaper to settle those claims where there's very little merit. And that's something that's very risky to do because claimants would often cotton onto the fact that, this insurer will not take us to court because it's too expensive. So they'll give us a nuisance value settlement of, say, 100,000 Rand. And 100,000 Rand is a lot of money in the greater scheme of things to claimants. To an insurer, it's a drop in the ocean because of the high cost of litigation. So if we do continue to see this trend of trying to offer nuisance value settlements, we run a great risk of seeing an increase in frivolous claims, which gives everybody a really, really bad name. So where to from here with regards to the private sector? I think insurers should, it's difficult because money talks. They should have a significant look at how they conduct business and assess claims and ensure that they guard against paying frivolous claims, even though it is more cost effective. And we need to take a significant and hard look at the Contingency Fee Act because right now the playing fields are not level from a cost perspective. In the ordinary course, the successful litigant is able to recover his or her costs from the unsuccessful litigant. The Contingency Fee Act is there to assist claimants because they do not have the funds for litigation. So even when a claim is successfully defended, the insurer is still left out of pocket because even though they have a recourse to recover those costs, that judgment is not executable because there's just no money to recover. Thank you.
Yeah. Thank you so much, Dion. So what is usually the court's attitude towards granting cost when a matter is successfully defended?
No, it flows that costs are granted to the successful litigant. However, there are different degrees of costs, and often there are punitive costs that can be awarded. The different cost orders that can be made are your party and party cost, which is a normal cost order. Then you get attorney-owned client cost, which is on a higher scale, which is all the cost, but it's payable by the litigant. And then you get cost de bona proprius, which in the event of a de bona proprius cost order, the attorney has to pay those costs. Unfortunately, at the present moment, it is only in the case where the attorney acted badly or unethically where those cost orders are being made.
Okay. So your suggestion is that the Contingency Fee Act should also help or be amended to assist
the successful litigants, in my case the insurer, from recovering costs.
Okay. Do you have perhaps a suggestion how that should?
If you want to see Eva jump out of his seat, I will say that that those costs are to be borne by the attorney.
Oh. Yeah, no, interesting one. At home, those who are tuning in, don't forget our Twitter handle or our hashtag is #ANC Legal Workshop. You can also follow us on SABC Twitter handle, or also on our Facebook on SABC Facebook page. We are therefore proceeding to Dr. Confidence Moluko, who has worked in the public sector of Department of Health. He is better placed, I think, to inform us from the doctor's perspective, from the medical practitioner's perspective. Dr. Confidence, the floor is yours.
Thank you very much for this opportunity. Let me just start by saying that having listened to my colleagues and fellow panelists talking, I'm more convinced that the increasing cost of taking cases to court, together with the high cost of insurance against medical negligence, especially in the public clinics and hospitals, are a threat to the national health system. They will make it more and more difficult for government and the health sector to deliver good quality health services. This cost will also make it difficult for doctors to deliver good care without fear. If not attended to, this will affect health care providers, the patients, and the public badly in the long run. The payment of very large sums of money to lawyers and patients as a result of lawsuits will also make it difficult for government to be able to finance health care, especially the planned implementation of the National Health Insurance as planned. The medical profession has to regain its status and stature and ensure that professionalism returns to be the hallmark of this noble vocation and profession once more. The legal profession will also have to play its part of seeing to it that it does not collapse the health system and contribute to the worsening of the culture where South Africa is a litigious society. In preparing for this debate, I decided to focus on the practical, what I see happening daily in our medical practices, in the clinics and in the hospitals, and also my experience as a former senior manager in the public service. It can be deduced from what has been already said by my fellow panelists, and it is also a very well-known fact that the cost of litigation and insurance against medical negligence has increased phenomenally in the last few years. One of my fellow panelists was saying that this is an international phenomenon. But my view is that it is called comfort to be made to accept that this is a global culture that South Africa must learn to live with. The two important areas of increase are the rising cost of medical insurance and the frequency of clinical negligence claims. It is said that the public sector currently is facing litigation that is in the region of billions, made worse by the backlogs, as already mentioned. And this figure is increasing. And if we look at this, it means that it is surely not sustainable. The threat to the doctors and those that are delivering services that is posed by these costs might force these professionals, most of whom who do their best to care and heal, to replace their good and compassion-based practice of medicine with a new culture in which they first think of having to defend themselves in court. This is called defensive medicine. This factor not only raises the cost of healthcare, but also affects the quality of care that the doctors deliver to their patients. Because the doctor is not thinking of meeting the immediate needs of the patient, but is worried about the possibility of being taken to court for a mistake that might be committed in the process of delivering service. The Minister of Health, Dr. Aaron Motsoaledi, has often expressed his desire to put in place a system that will put the doctors back in the clinics and hospitals and lawyers back in court, and not vice versa. He has tackled this challenge vigorously, as it has already been said, and he has put in place mechanisms and a task team that has to assess the extent of the problem, to objectively identify contributory factors, and to consider possible intervention measures and solutions to the problem of medical negligence and litigation as it affects the health sector. Let me just state it at the outset that inasmuch as the delivery of health care to people who are ill and injured means that some of them will not make it, those patients who have got legitimate claims have to be compensated fairly and justly. This must be done in line with the Constitution of the Republic of South Africa, and also in line with the aspirations that are enshrined in the Freedom Charter. Having said that, let me just give 3 examples of actual cases that are very simple and basic, but which open the national health system to litigation. Case number 1. An official of the Department of Social Development is contacted and is told that there is a case which needs care. The care that the case needed was not necessarily health care, but had to be seen by someone from social development. No one goes there until the end of the day. And conscientious doctor gets into his car, goes to the family, and goes and sees that patient and finds that that patient is having very serious problems. Tries to call an ambulance. The ambulance takes 3 hours in the center of a very big metropolis to arrive. Now, if anything happens to that patient, we are going to be saying that there is no need for us to litigate. I think that this is one of those cases where if anything happens, the patient will have to be compensated and the family will have a right to stand up and say, you have not done your work. Now, the second case is the case of a specialist physician sending a patient to the public sector. What happens in many instances is that even when a specialist physician or a specialist surgeon has sent a patient to the public sector hospital, in most instances that patient is started from scratch, where the patient is seen by an intern or a very junior medical officer. Now, for us to avoid a situation where there are very serious problems, there needs to be communication and respect restored between the public sector and the private sector, not this animosity that sometimes is experienced. Now, this patient who has been sent by a specialist, having a very acute problem with his heart, is left unattended for a number of hours. And when the junior doctor is asked, he says, I have not attended to that patient because there were other emergencies. Now, that becomes a problem when the patient complicates. Noting that we are having these conversations with the majority of the people who are neither lawyers or doctors, I found it best just to focus on two easy or simple but very important aspects, which are namely lapses in management in our facilities and issues that are related to professionalism. Now, starting with professionalism, we have to ensure that health professionals are trained to the highest standards, that the practice of medicine and nursing is maintained at their highest level in line with the Hippocratic Oath and the Nurses' Pledge. In carrying out their work of caring for the sick, health professionals have a duty to manage the risk of delivering care, to minimize unwanted or bad outcomes, and to ensure excellent professional interactions in the process of their work. The second issue, which is management. One of the key responsibilities of those who are in charge of medical practices, clinics and hospitals, public and private, is that there has to be good management all round. This includes ensuring that adequate records are kept by relevant health professionals from the time of first interaction to the time of discharge, even in those cases where the health professional has got high volume of work and stress. Point number 2 of management is that we have to ensure that all facilities have what we call clinical governance structures, or forums where groups of health practitioners meet regularly to discuss their work, the good that they do in instances, and also instances where there might have been mistakes and failures. Always making sure that these structures exist, are functional, and meet regularly. There are many health institutions, public and private, especially in the public sector, where you find that the clinical governance structures are either non-existent or not functional. Ensuring that clinical records are created, kept, managed well, and also protected in line with the law. And lastly, to ensure that we prevent touting, as has already been said, or collusion of staff with people from the outside of these clinics and hospitals to illegally access records and patient files. This includes the prevention of corruption, plus action against theft of medical records for sale by employees of clinics and hospitals to members of staffs of law firms. The general argument that is tabled in defense of health professionals in many instances in South Africa is that we have a national health system that is under heavy stress as a result of heavy burden of diseases, inadequate human resources, and insufficient funding of health facilities, especially those that are in the public sector. This is what was being referred to in the question that has been asked earlier as staffing. Now, let's look at the reality. When we compare South Africa with other countries in Africa, South Africa is better resourced in terms of budget and also in terms of the availability of health professionals. Many countries depend on foreign funding or donors for their budgets, whereas South Africa depends for its finances on the taxes and also from contributions by workers and companies. And South Africa's availability of doctors per 10,000 population is on the average double of those of most countries in the SADC region. South Africa, as compared to Botswana and Zimbabwe, has got 8 doctors per 10,000 population, whereas Botswana and Zimbabwe have 4 and 2, respectively. Now, if we compare ourselves with BRICS, South Africa is in fact better than India, because India has got 6 doctors to 10,000 per population. China and Brazil have got 12 and 14 respectively. This is the reality of the South African situation. There are instances where we can say that there are shortages of health professionals, But when we compare ourselves with our neighbor Mozambique, the outcomes that we get from health professionals is far much better in Mozambique, which is poorly resourced, than in South Africa, which is better resourced. We should not forget that South Africa has got some of the best trained health professionals, and that is the reason why we lose many of them to other countries. However, the professions need to constantly review the training of those who are destined to enter the profession, as failure to do so results in graduates who are ill-prepared to handle basic challenges to their professions. As I prepared for this debate, I tried to identify some of the examples of instances which pose huge risk to the national health system. The first one is inadequately trained health professionals. We cannot deny the fact that there is evidence that South Africa suffers from the malady of some of the most professionals having lost or busy losing that professionalism associated with their areas of practice. This is not a phenomenon that affects only the medical profession, but it is a phenomenon that I would say that professionalism has been thrown out of the window in many cases. The second point is fraudulent personnel working in the public and the private health sector. Here I will give an example. The Professional Board for Emergency Care discovered in August 2011 that some emergency medical services or ambulance personnel were working without the required qualifications and in most instances with fraudulent certificates. Since that discovery, the Professional Board is said to have removed 1,400 individuals from the register of the HPCSA. Now, if we take that number and we convert it into risk, it's quite high. The third point is the abnormal rates of performance of certain procedures. If you look at the rate of performance, for example, of the cesarean sections in the public sector and in the private sector, you will find that the rate in the public sector is around 20 to 30%, whereas in the private sector is 60%. One can deduce from that as one of the professors that trained us in obstetrics and gynecology used to say, you probably are not having cesarean sections. You are having what they call vaginal bypass, because you are delivering babies without the indications, proper indications, obstetric indications of a cesarean section. The solutions that we can be looking at is, first of all, to make a call to the medical profession that the medical profession cannot and must not continue to abdicate its responsibility to other professions, to government officials, and to NGOs. The medical profession has to pull up its socks to return this noble profession to where it belongs: noble, compassionate, honorable, and independent. The medical profession has to put measures in place to ensure good practice and less malpractice. Professionalism. The medical profession and other professions operational in the health sector must redouble their efforts to make practitioners return to the professionalism that is the pride and hallmark of their professions. They must make practitioners proud of belonging to these noble vocations and professions. Management. Good management must be demanded as part of a return to basics, even in the public health sector. The simple fact, which is poor management, is in most cases the root cause and the root of failure of delivery. This includes the management of performance of professionals and the management of clinical records. Government generally as a whole. The policy vacuum and absence of unity of purpose that exists currently on how medical negligence and litigation should be approached must be closed, so that we can have clear policies that guide the nation on how this should be approached and what should be considered in litigation. Government should seriously consider legislative measures to reduce the escalation and impact of litigation. It must work together with the profession to define objectively and scientifically concepts such as future earnings. That has already been mentioned by some of my panelists. In cases such as cerebral palsy, when you hear people talking about future earnings as they affect cerebral palsy, you then can understand that they don't understand that it is a condition that might be caused by factors not related to the delivery of services or actions of health professionals. Touting and selling of medical records has already been touched upon, and of course, good medical insurance for professionals, as already having been mentioned. Thank you very much.
Thank you so much, Dr. Confidence. Now, if I were to play devil's advocate with you and ask the question as to whether you have alluded to the department trying its best to curb or to prevent litigation at all cost, or the collusion between employees of the department and attorneys. Now, in an instant where a person has been affected by medical negligence and no attorneys involved at all, the person lacks knowledge of the fact that they can approach a court of law with regards to this medical negligence. Does the department then take it upon itself to address this issue faced by that person? What does the department, in other words, do in order to make sure that this person is compensated, or an explanation of some sort should be given?
I cannot talk on behalf of the department, not being part of the department. But from my experience, I have witnessed cases where the affected parties, when they raise the issues with the professionals in the public sector, if there is good communication between the people who are delivering service and the people that have been wronged, there have been cases that have been resolved without having to go to court. And that has been alluded to in the submissions that have been made earlier. The most important issue here should not be prevention of litigation, but it should be to care and to heal without harming the patients.
Thank you so much. Before I go to Mr. Likabe, there's a question which I think I'll just pose to the minister here. On Twitter, I say, why such things are discussed by the ANC rather than the relevant health science professionals and the institutions? Perhaps you can answer this one.
Well, I think the issues are being discussed by the Department of Health. I know that the Minister of Health is very concerned, particularly with respect to the training of health professionals. The care with respect especially to that given by nurses is one that enjoys particular attention from the health department and the ministry. There's been a significant shift in the training of nursing health professionals, in that primary health care, preventive care, and this adherence to standards of ethics, understanding how one manages patients at the bedside and so on, has been seriously eroded by the shift to universities and health faculties, rather than training within nursing colleges or practically at the bedside, which was the practice in the past. So the nature of training needs to be addressed, and I know that the health department is looking at this and is improving its own oversight of the quality of health care within the public health system. The creation of an ombud, for example, has been a very important step. Regular reviews of provision of health care and introducing a system of monitoring and evaluation within the public health system are all steps toward improving the system's ability to respond to patient needs.
Thank you. I think that was widely sufficiently answered. I think I could just take 2 or 3 questions from Mr. Maodi.
Thank you. Thank you, Amanda.
Please stand up.
Thank you, Amanda. My name is William Maudi. I'm with the Black Lawyers Association. My question is directed to Dr. Moloko. In fact, let me preempt before I ask a question. For a medical practitioner of Dr. Moloko's caliber, who started studying medicine during 1980, 2 years before I was born, I am shocked that he justifies that a child that is born with a condition of cerebral palsy, whose parents are indigenous and illiterate, to the extent that should they not know or bear the knowledge that they have a constitutional right to approach an attorney to ensure that the child is adequately compensated, for him to see that as an error on the part of a legal practitioner, it's shocking. The legal profession has relevant bodies such as the Law Society as well as the Attorneys Fidelity Fund to ensure that any doctor who acts with malice in protecting the interest of the very same child you spoke about that is born with cerebral palsy, are you not concerned of directing your energy, dating as back as when you acted as an advisor to the Minister of Health, to ensure that health professionals are adequately trained for them to produce the same results that we're talking about and avoid litigation?
I would give Dr. Confidence the right of reply.
Thank you for the question. Ndate Maudi, you are assuming that cerebral palsy is caused by medical negligence. Cerebral palsy can be caused by factors that are outside of the place where the baby is formed and grows, which is the uterus. I'm sure you have heard about the Zika virus. And the reason why it is being taken as a serious infection that has got to be tackled. And one of the main concerns that the world has is that those that are exposed when they are pregnant to the Zika virus, they then give birth to children who are mentally impaired because of the damage to the brain. There are those things that can happen when the child is born. And some of those issues, that is why I've said that in cases where patients have got legitimate grounds to lay a claim, that we have to make sure that the patients are compensated justly and fairly. There are some of the patients that end up having cerebral palsy as a result of what happens after the child has been born. So from the statements that you have made, I would humbly advise that you should just go through and understand the causes of cerebral palsy, and then you will appreciate that I am not defending malpractice, but I'm saying there must be a thorough understanding of any condition before we make up our mind, even from the side of the legal profession. If the legal profession is not informed about the causes of cerebral palsy, then it should confer with the medical profession to have a better understanding of the illness. Thank you very much.
Thank you. I think there was a hand. Okay, you can go ahead, Mr. Sibego.
Good morning, everyone. My name is Yanda Sibego, and I've got a question in respect of the increase in medical malpractice, which was raised by Dion and was further elaborated by Dr. Confidence. My question is a very pointed one, and I'd like Dr. Confidence to weigh on this. My question is relating to the recent comments that we've also heard from the Minister of Health, Dr. Aaron Motsoaledi, regarding many general medical practitioners now becoming very reluctant to specialize in areas like gynecology and so forth. So I wanted to ask how can we reach that compromise, that middle ground whereby we are sure the benefit of the victim of malpractice, and also not to have an increased number of general medical practitioners refusing to specialize in areas like your gynecology and so forth.
If I may ask you to respond, however, please kindly be brief.
Thank you for the question. I'll be brief. The last part of the medical professionals being reluctant to specialize because of what we call highly risky professions, like gynecology and obstetrics. I did touch upon it, and I've said that the greatest difficulty that arises from the fact that we have got this growing global culture of litigation is that if we do not stop that, we will find that when a doctor goes to treat a patient, the doctor will start thinking about the court and not the needs of the patient. Now we have to find a way to deal with that culture, which is far much prevalent in the Americas, where you can be sued for anything. So the cooperation that is there between the professions, that is the medical profession, the legal profession, and also the interventions that I've mentioned, will assist in curbing the escalating cost of insurance and also the frequency. And I have also mentioned that having to work very hard on making sure that professionalism is returned to the profession. That is one of the things that will deal with the second part of your question. You have talked about the increase in malpractice. I think various panelists here they have already touched on that, and also I touched it when I was making a submission. I hope you answered. Thank you.
Thank you. If I may just go to Mr. Lekabe because of time constraints, and I can allow questions afterwards. Mr. Lekabe, if I can just introduce you, Mr. Lekabe is a state attorney, probably one of the most out of this discussion who have to bear the litigation in the public sector by defending the Minister of Health in this medical negligence claim. I'm sure his office is full of these files. I'm sure they even have a department dedicated to this. Mr. Lekabe, you can.
Thank you, Problem Director. We are currently dealing with approximately 1,600 of these matters, and almost 99% of those matters, the cause of action is the injury to the brain during childbirth, which has resulted in cerebral palsy. For a number of factors, we're finding it very difficult to mount defenses in these matters. And I'm going to indicate a number of matters that militate against defenses. Dr. Molugo has mentioned one of the factors is proper record keeping. Currently, there's one of our attorneys who is attending to 12 matters that are on trial in this month. In all of those 12 matters, there are no hospital records. It means we go into court, we've got no ammunition at all. We are wondering as to how we are going to defend those matters. As a result of that, the experts that we engage and have been engaging are saying now, sorry, I am not going to put my professional integrity in jeopardy by expressing an opinion without hospital records. So we go to court, we don't have an expert. What do we do? Minister, what do we do? We have to settle. In instances, and in the very few instances where there are hospital records, the hospital records are lacking detail. I have, on a number of occasions, spoken to, I think it was one doctor that was heading the department, and I said to him, the notes, for our purposes, bear in mind, as doctors, when you write notes, you're not only writing for yourselves. We go through notes, the notes are encrypted. Okay? When you read through it, you can't understand what the doctor was saying.
Sure can.
We at a consultation, we call doctors, and we say, but what does this mean? A doctor would say, I don't understand what the author of these notes wanted to connote by this. Okay, I suggested to the head of the department then, and I said, please, can you send messages to all clinicians and say, these notes are written. Bear in mind, it's not only doctors that read these things. Legal people and judges like Judge Lasena, they wouldn't understand the nomenclature used by the. So give us detailed notes. And the response that I got was, there's a standard in place in terms of which notes has to be made. This is how we make it. So that is the problem that we sit with. The records, Minister, I'm going to say this. We ask for records from the department. The department would say to us, let me say this, a medical negligence matter in many instances starts this way. It's by a letter of demand. The department sends us a letter of demand. We open the file. There's a standard part of the letter that says we are tracing the hospital records. Okay, so we sit back. We keep on writing and we say, where are the hospital records? We get no responses. Okay, 1 year down the line, we get a summons. We still don't have hospital records. We have to go and put a plea. There are no hospital records. We don't have a version. We have had to put our professional integrity in jeopardy by putting in bad denial defenses. You know, lawyers would know. I think the Law Society would frown on that. But I put my hand on the block, and I said to those that report to me, we do it. If any one of us is in trouble, we will have to go and fight. I will go and I'll take cudgels on your part, and on your behalf, and go and fight it, because we just can't fold our arms and say we don't have a defense. So I said to my colleagues, we are not going to be dogmatic about it. The one particular part of the record is what they call the CTG tracing, the CTG tracing, or the pathogram. This is the recording of the birth process during labor. Somebody has to sit there at that machine. I don't know what they call it. They call it a cardiograph. Cardio, yes. Somebody has to sit there during the process and observe, so that he can alert the clinician or whatever, or the midwife, if there is a change, if there's a fetal distress, and so that something can be done about it. I've been taken through some of the wards in the hospital in Gauteng. What I observed is there's a serious problem of manpower. There are no people that can man those machines. There are instances when those machines are dysfunctional. I was told at Baragwanath Hospital there are about 14 of those machines. I was told per week something like 450 children are born. So you can imagine, if there are, at one stage there are more than 14 children that are being born, ladies that are in labor, it means there is no machine for some of these in order to observe the birth process. We have been lampooned by the courts because we don't have the records. The lady that was in labor, the claimant or the plaintiff, would come and say, I was at the hospital for 24 hours. I was not attended to. Nurses were watching generations. I was left to my own devices. This is how she testifies in court. Can we put any doubt to that version? We don't have the hospital records. So there is no way we can cross-examine and say there's no truth, there's no veracity in what you are saying. So we lose. And you know, in the many instances, and it is there, Minister, it has been said, I don't know, it's for the first time that the state attorney comes and speaks publicly like that, because in the past it appears as if the state attorney hides under the table.
It's also the first time he's got a minister in front of him.
Yes. He hides under the table, and that's it. So it is encouraging that we are having this interaction. The second problem that we have, Minister, and Dr. Moloko mentioned, I think Dion mentioned it in part, and it's the issue of the shortage of experts. In a cerebral palsy, in actual fact, a relevant expert there would be the pediatric neurologist. He has mentioned that in the country there are only 3 of them. If in one, like I indicated, if one attorney in our office is dealing with 12 matters per month, you can imagine. We need those kind of experts. You know what we do? The kind of service, Minister, that we render, it's substandard, because we end up getting an ordinary neurologist because there's no relevant expert to deal with it. There is also this thing, and it permeates throughout government. Maybe I've not been long enough in government. I've never been able to understand it, and I've not been able to close my eyes to that. There is a lack of understanding on the part of government departments as to the state attorney's role, their mandate, as well as their powers. The jury is still out on this particular issue, Minister, because there's a pending matter before court here in Johannesburg, where I've been cited as one of the respondents, because I did what the State Attorneys Act mandates me to do in the situation. I do know, as a matter of fact, when you talk to people that have been in government for a long time, they say, no. The departments don't have to use the services of the state attorney. There is an opinion that was drafted some time back, and they rely on it. Instead of relying, those that have an interest can go and check on the mandate of the powers and mandates of the state attorney. There's a Supreme Court judgment that clearly defines those powers. But many of the government departments just ignore. And then this particular factor, as a result, results in frosty relations between us. When we're supposed to work as a unit, we are working at cross purposes. The other thing that militates against this is, there are processes in court.
Mr. Mugabe, unfortunately, because due to time constraint, kindly be brief as you can.
Yes. Okay. Let me say this. We've had so many difficulties with how we should defend these cases. We've had to survive in the midst of all these problems that I've articulated. We firstly raised the issue about for somebody, one of my panelists mentioned the issue of future medical expenses, which Minister, in an instance where the award is 36 million, almost 98% of that is for future medical expenses. What happens to this? We pay the 36 million. The contingency and the issue that Advocate Kaji raised, the contingency, the attorney takes 25% of the 36 million. So already the child, the money that's supposed to take care of the child has been diminished. If the child needs medical attention, what happens? The child would go back to a private, to a public hospital, because the Constitution says there's an entrenched right of access to medical health care. There is no way that the hospital would say, no, we've paid you 36 million, we can't teach you. We have raised this issue, and it's one of those. What we have done is we've developed what I call constitutional defenses. And one of that is what we call the double jeopardy, Minister. Because we pay the 36 million, and the next moment the same child comes back to us. We can't say, we can't treat you because we paid you the 36 million. We have also raised an issue. We say, the Judge Larson mentioned, these awards are paid from the budgets of the various hospitals. Can they afford it? The money is intended for medicine and for equipment, for getting staff, for ensuring that there's a proper functioning health system. But the money is diverted to something different. What about the right? The right of access to public health remains a pipe dream, because 36 million is paid to one person. And I go to a public hospital, there's no Panado, because the money, the budget has been whittled down. We have also raised that as a defense in these matters. We have invited the court to use its inherent powers, and I'm just quickly going to say what Section 173 of the Constitution, it says, the Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each has the inherent power to protect and regulate their own process and to develop the common law, taking into account the interests of justice. We have argued and we said to the judges, please develop the common law in line with Section 173. We do know. We started, in actual fact, when we realized these high claims, we tested the waters at our office. We asked counsel to go and argue and say we will provide an undertaking. And the judge in that matter said there's no legislative framework. You cannot determine as to how the plaintiff should be compensated. The plaintiff wants money. You can't force an undertaking down their throat. That has been, we tested that in 6 consecutive matters. We were given a PAMELI by the judges. But my impression is judges just want to follow previously decided cases without sitting there and looking at it. But on a positive note, let me say this. In all the 6 matters, we applied for leave to appeal, which was refused. We petitioned the SCA, which was refused. But there's a matter of maximum for those that have access to the thing. Yes, I'm good. In that matter, the judge granted us leave to appeal, where she had ruled against us on those issues. We have a particular kind of a plea that we filed in each and every matter. Our opponents laugh at us and say, but in the 6, 7 matters you have lost. Why are you still coming with these arguments? What has happened, positively what has happened is this. The SCA has now given us leave to appeal in 2 matters, where we have raised those constitutional defenses, and we are looking forward to that. Just in conclusion, the government has done something about it, Minister. As you have indicated, the Minister of Health, I went and articulated these problems to him. He has done something about it. the MEC for Health, and I say thanks to her, she's also done something. There's been a referral of the issue to the Law Reform Commission, which is busy with legislation.
Thank you, Mr. Rekabe. Thank you. Thank you. Thank you. I think, Madam, you can ask your question. I see you've been holding for some time now.
Thank you very much. My name is Anna Granova, and I'm an advocate at the Johannesburg Bar. I believe in the power of knowledge, and that's why for the past 2 years I've been presenting free lectures to the Wits University as students who want to specialize in gynecology.
Kindly note that we only have 10 minutes left. I need to take other two questions.
My suggestion today is that a basic course on principles of medical negligence should be presented to all medical students so that they can be less scared of the law and more focused on what they want to become, and that is doctors. Thank you.
Thank you.
Can I answer that, please? We are at the South African Medical Legal Association currently under the chairmanship of Dr. Edling devising such a course as you have suggested now.
Thank you. I'll take also a question, just briefly, very brief, please.
Okay, very briefly, sorry. Hassan Kaji. Thank you for the panelists, but since we're short of time, I think what the government really needs to do is improve on resources. Mr. Likabe spoke about it, and so did Dr. Confidence. When you go to Baragwanath Hospital, the busiest hospital in the Southern Hemisphere, you had, up till 2009, just one theater for cesarean births, and you had like 60 people coming in every day. They have to improve that. They have to put more money in buying equipment. When it comes to litigation, there's a problem with the budget that the state attorney has, because they can't pay the rates that the private firms pay for their own legal representation. That causes a problem as well. When it comes to the contingency fee agreement, there's nothing wrong with it, because it's not 25% of the capital amount. What attorneys have been doing is very naughty. They've been taking that 25%. The law is clear. It's twice your amount that you normally charge, or 25%, which is less. And the courts have stressed on that. There's judgments about that. And we also need to also look at the fact that the attorneys take the party and party costs that go to the clients. They take it and put it in their pockets. That's the law society that has to deal with it. But at the end of the day, government has to improve on resources. We need to build more medical schools, more nursing schools, so we get what we need. It's a pity that the time is short, so I can't really touch on it. But hopefully, we'll do it with the legal research group. Thank you.
Thank you. It is unfortunate that I cannot take all hands, but there's a lady up already, unfortunately. Yeah, I'm going to come to Dr. Edlin and call. I'm going to give you literally 90 seconds.
Thank you. My name is Tando Tsetsewa, and my question is to Dr. Maluk. I just want to find out quickly, you mentioned something about within our clinics and hospital having this, what you call a clinical government structure. I just want to find out what is that, what will it encompass? Because I've also worked as a state attorney, and it's really difficult to defend some of these medical cases. And whether will these structures then assist in ensuring compliance, accountability, and professionalism amongst the medical staff? Thank you.
Dr. Confidence, you can respond to it, but maybe in one sentence.
The doctors and nurses meet regularly to review all the cases that have passed through the wards. And they say, these are the good things that you have done. This might be the things where you have made the mistakes, and they record those. And there is protocol that is followed to record those cases that might have been mismanaged.
Thank you.
Thank you.
Now, for a brief comment from Dr. Edling and Dr. Cole, you have to share the 60 seconds.
Thank you very much. Honourable Minister and Madam Chair, I'm here in my capacity as a director of the South African Medical Legal Association. We are an apolitical organisation of professionals. We are at a meeting of the ANC, which is a political party. I wish to applaud the ANC for hosting this meeting, because it is clear from everything that has been said at this meeting that the aims and purposes have got nothing to do with politics. That the purpose of this meeting, and I hope the future work of the ANC legal research group is for the greater good of all South Africans. That impression is what I've gained, and I wish to applaud everybody involved for that. As a medical practitioner and a medico-legal expert, I wish to emphasize that we are talking about downstream harm. Harm occurs at the point of negligence. And most of what we've been talking about has been downstream. Some comments, especially from Dr. Moloko, have been on upstream.
Unfortunately, I've got 2 minutes left. I need to take it to Mr. Kajus to give our vote of thanks quickly.
That the most important place to avoid the bleeding purse from the purse is to prevent negligence. And I believe the ANC can employ creative thinking with the assistance of intellectual capital that is in society outside political parties to curb the harm and stop the damage. Thank you.
Thank you.
I'll be very brief. Peter Cole, I'm a gynecologist in private practice. I think the most important point to get across is just how serious the situation is with medico-legally. We're facing, if we carry on our current course, obstetric care in this country is in very, very serious jeopardy of total collapse. And I think we have to understand that, we have to appreciate that. And if we don't do something to change our direction, we're going to end up where we're heading, and that's going to be a total disaster. Why particularly obstetrics? And I think the reason obstetrics comes under fire, the medical profession, one must appreciate, is a risk management profession. The legal profession is largely a risk avoidance profession. We manage risk, and I don't think people fully appreciate the risks involved in childbirth. And I think that's why obstetrics is facing such a particular problem.
Thank you. I don't think this topic can be covered widely enough, but I should think that what we have covered today will spark the necessary debate and would eventually lead to law reform. Mr. Kajus, kindly do our vote of thanks.
Program Director, Judge Claassen, Honorable Minister, all the panelists, representatives of SAMLA, members of the Johannesburg Bar, thank you for your good turnout, BLA, and Nadel attorney's profession. We really appreciate you being here. Of course, this is a very complex issue, and we have only touched on some of them. We can't do full justice to this in a 2-hour session, but we hope that this will foster further debate out there, and we hope that whatever has been discussed here will be taken seriously by the Reform Commission, and this will just not be another talk shop. Thank you.
Thank you so much. Thank you to everyone who has attended and everyone who has been watching from home. Thank you to our viewers of the SABC channel 404. Thank you. Sure. Yeah. How was that? How was that? Unfortunately, the time was not enough to discuss everything, but I think we covered more than this and that.
Sven, hoor jy? Okay, ek het jou gehoor. Sê maar net. Ek glo dit behoort te wees, almal is uit so. Dankie.